The Law and You. A look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You. Presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.
Ladies and gentlemen, brothers and sisters, boys and girls, greetings. Welcome to another presentation in this public service nation-building series, The Law and You. This is program number 826. Coming to you on Monday the 30th of May 2016. On this program, I will speak to you on the topic duties of administrators. But before getting into the topic, a few preliminary remarks. Firstly, I apologize that I was not able to bring the program last week. For the last 3 weeks, I have been at home, not feeling well. In fact, I practically couldn't walk. I was afflicted by a condition known to some as diabetic nerve pains, to others as gout, but what it meant is that from the base of one's big toes right up to the knee was very, very painful, and there were days when I couldn't even walk out of the bed without assistance. But thanks to the good doctors who have attended to me and the medications they have prescribed, I am significantly better today. And I want to thank the Lord for restoring me to health. Unfortunately, as I was getting better with the feet, yesterday I came down with something else, having to do with what I had eaten the night before. And unfortunately, I couldn't make it to Mother Dick's funeral. Now, Mother Eunice Dick of Belmont was a member of our church, the St. Elizabeth Spiritual Baptist Church at Belmont, and a mother of whom I was extremely fond. And I was quite saddened when I heard of her death, but devastated when I realized I couldn't go to her funeral yesterday. So to all of Mother Dick's relatives, my deepest condolences. Members of the church would know that whenever she came to church before she had her amputation, I would go and greet her, especially once she came to the church. And since her amputation, she has only been able to make it out in a couple times. She was house-ridden. I know her children and other relatives would miss her very dearly, and I, for one, would miss Mother Dick so, so much. And I was really devastated when it occurred to me that I couldn't go to her funeral yesterday afternoon. But such is life. And again, due to my illness, I couldn't go to the funeral of a very dear friend of mine, Charles Burnett. I met him at Rockies when we went to live there in 1961. And Charles and the whole Burnett family became very dear friends of mine and of my family. So to all the remaining members of the Burnett family, once again, my deepest condolences. And if I was up and about, I surely would have made it to the funeral of that policeman who was slain at that function in Belmont. Terrible, terrible. My condolences to all families which have suffered recent bereavements. And as the old people say, only those who know it feel it. On a happier note, let me issue my warmest congratulations to my aunt, Mrs. Emily Ballantyne of Leo, who celebrated her 93rd birthday last Wednesday. Happy birthday belatedly, Tanty Emily. We all love you and we had a lovely time at Layu when we came down to see you on Saturday. Now, I have several legal clerks employed in my chambers. One of them was arrested 2 Saturdays ago and taken straight up the aisle as the bride of Constable Jermaine Durant. He was the arresting officer. So, Mr. Durant, you have arrested my clerk, you have taken her in marriage, and I wish you and Luan all the very best. So for all you legal clerks, it is no more Miss Bracken, it is Mrs. Durant. And for those lawyers of our acquaintance. So, Mr. and Mrs. Durant, my very best to both of you as you start your journey together as a married couple. Of course, you all have known each other for a good many years. And now that you have taken the former Miss Bracken as your lawful wedded wife, I know that you will continue to love her and cherish her just as she would continue to love and cherish you. So for the last time, let me say all the best to you, Bracken. But from now on, I would have to call you not Miss Luan Bracken, but Mrs. Luan. Mrs. Luan. I'll have to get accustomed to that. All right? Okay, Mrs. Durant, Mr. and Mrs. Durant, the law and you. And let me not forget one more preliminary. I was specifically asked by one of my nephews to answer a burning question which had been raised by a gentleman of his acquaintance. So, Master Kyle, this is the answer. Now, you indicated to me that this gentleman lives next to a river, and that the gentleman has said that according to his understanding of the law, if you live next to a river, you can claim half of the river or some such. Well, let me tell you, no one, it doesn't matter how many years you have been living next to a river, no one can claim any rights in the river any more than any other member of society, because rivers and riverbanks belong to the Crown. After all, rivers flow from the mountain down to the sea. And no one is permitted to dam up a river or to divert the course of a river. That is for the governmental authorities to decide. So you who live next to a river, you have no more rights than anybody else. Don't fool yourself into thinking that you can do what you please with the river because you live near to it. And it is important, and let me warn those who live near the rivers, do not pollute the rivers, do not throw rubbish in the rivers. Do not throw excrement in the rivers. Don't wash out your pans of insecticides and herbicides and pesticides and throw the contents in a river. In other words, don't do anything to the river that you wouldn't want somebody who lives above you along the course of the river to do to your detriment. So young Master Kyle, tell the gentleman that Mr. Campbell has said under law and you that he, the gentleman, has no greater rights to the river than anybody else, and everybody else's use of the river is subject to the Crown's authority. Rivers and river courses belong to the Crown. The Crown means the government. All right? Okay. Now, administrators. As everybody knows by now, when we speak of the administrator in relation to the estate of a deceased person, we are speaking of somebody who has been authorized by the High Court to take control of the property of the deceased person and to deal with the property according to law. There are two general principles of law in respect of the property of deceased persons. One principle is that if the deceased person had left a will in which an executor was named, then from the moment of death, that executor becomes legally authorized to take charge of the property of the deceased person, the testator, the one who has made the will. So the authority of an executor begins with the death of the deceased testator. The second legal principle is that where a person dies intestate, that is, without having left a valid will, that person's estate automatically vests in the Chief Justice. And when someone applies to the Chief Justice asking to be appointed administrator, and the Chief Justice agrees and authorizes that person to act as administrator, a document is given to that person, which is referred to as letters of administration, authorizing that person to take charge of the estate of the deceased. So to recap, if a person dies testate, that is, having left a will, the executor of that person automatically becomes in charge of the estate of the deceased person from the death of the deceased person. The moment the person dies, the executor's powers begin. But if the person does not make a will, that is, if the person dies intestate, that person's estate vests in the Chief Justice automatically. And it's only when somebody is granted letters of administration, the Chief Justice says to somebody, look, you are now authorized to handle the estate of the deceased person and to deal with it according to law. So on this program, I want to look at some of the responsibilities and limitations of administrators. Let us assume that somebody who is qualified to apply, and Not any and anybody could apply for a grant of letters of administration. But I've dealt with the qualifying aspects a bit on other programs. Probably in the future I may come back and deal with it again. But let us say someone is qualified to apply and applies, goes through the normal processes, and is granted letters of administration to the estate of the deceased person. The law regulates what that administrator can and cannot do. And what I want to emphasize on this program is this. When somebody gets a grant of letters of administration, it doesn't mean the person is authorized to do as they please. No. But I have come across very many cases in which somebody gets a grant of letters of administration from the High Court, having duly applied for the grant, and then turns around and behaves as if the estate of the deceased person belongs to them. They do not distribute the estate in accordance with the law. They turn and do what they feel like, sell parts of the property, keep the money, or give who they want, rather than give those who are legally entitled, and generally become bossy, as if they can do anything they please. No, no, no. The law governs what an administrator can and cannot do. The first thing the administrator has to do when he or she is applying for a grant of letters of administration, he has to, and I would stop saying he or she, I would just say he, but by that I mean the feminine as well. He, the applicant who is applying for a grant of letters of administration, has to identify all the persons who are entitled to share in the estate depending on their relationship with the deceased person. And in that application, those beneficiaries have to be identified, and the shares to which they are entitled also has to be stated on one of the application forms called the estate duty affidavit. Now, suppose the applicant deliberately leaves out persons whom the applicant knows should be included. That is a serious offense. And persons can go to jail for deliberately leaving out of the list of persons somebody they know ought to be listed. Nowadays, all children are regarded by the law as equal. So if somebody dies intestate, leaving children within a marriage, and other children which the person had outside the marriage, the applicant can't take it upon himself just to list the children within the marriage and leave off the children who are outside on the grounds that they were outside children and they don't matter. You can't do that. Once they are children of the deceased, you have to put their names down. You can't say, well, the deceased name, the deceased man's name was not on their birth certificate. The duty of an applicant is to advise the children, who you know are the children of the deceased, that they should take steps, or their mothers should take steps to get declarations of paternity through the legal process, and there's a process for that. But you can't deliberately leave off people's names because you don't like them or they are outside children. All children have to be included. Once you are aware that so-and-so person was regarded by the deceased as his child. If there is any dispute, you can always resort to applications for medical tests to be done. So that is one thing. When you are applying, you have to make sure you include all the names of beneficiaries who should be included in an application. But it is even worse when you include their names in the application papers, and yet when you get the grant, you then distribute the estate without giving anything to those very people whose names you had put down on the application papers. You could also go to jail for that. And when it comes to the division of property, the law is clear as to what proportion should be given to whom. For example, if the deceased person left a spouse and the children, the spouse is entitled to 1/3 of the estate and the children are entitled to the other 2/3, divided amongst them equally. Now, you can't take it upon yourself if you are the administrator and you are not the spouse of the deceased to say, well, the widow of the deceased never used to treat him properly, so you're not giving her 1/3, you're giving her something, but not 1/3 because she never treated the deceased person right. Didn't look after him, didn't care him in his illness, and therefore she is not entitled to 1/3. That is not a point you can take. That is not an attitude you can take. The law says the widow or widower of a deceased person is entitled to 1/3 of the estate of the deceased person if the deceased person did not leave a will and had children. Now, if the deceased person just had a spouse and no children, then the spouse gets 1/2. And the other half would go to other relatives of the deceased person. Firstly, their parents and brothers and sisters, uncles and aunts, grandparents, and so on and so on and so on. Now, if in doubt, you must refer these matters to your lawyer for advice and clarification. And no lawyer is going to advise his client to do that which is not just wrong but unlawful, and which has the potential of criminal sanctions. So that administrators, persons who have got a grant of letters of administration from the High Court, are trustees of the estate. And if there are more than one administrator, if there are 2, well, you seldom get 3, but you can. But if there are 2 co-administrators, and if they are female co-administratrixes, then they are jointly responsible and severally for doing that which the law has authorized them to do. I have dealt with previous programs in which I've used the word dead left. And believe you me, there are so many instances of people fighting over the property of deceased persons, particularly in cases where some of those who are fighting played no role in assisting the deceased person during their lifetime. I have known families who have packed off the old people to the Lewis Burnett home. Don't even bother go and visit them, but the minute they hear they die, they run in to find the bun pan book. They run in to bury the deceased so that they could claim what the deceased had. And if you speak to the authorities at the bun pan, they will tell you what scramble there is. Sometimes 2 or 3 people end up out there quarreling as to who is entitled to get the book. Because the book comes with, assuming the book is financial, there's a funeral grant. And those who don't deserve to get the benefits of the estate of the deceased are usually the first ones to rush and make big noise that they should get so and so. But I say that by the way. So in sum, those who are charged with the responsibility of looking after the estate of deceased persons have a serious duty to perform, and they have to perform it in accordance with the law. The law dictates what you can or cannot do with the estate of a deceased person. If in doubt, get legal advice from your lawyer. But you're not free to do what you feel like doing. All right? So that is all from this program number 826 of The Law and You. I thank you for bearing with me for the last week. The week before that was a public holiday when we did not naturally have The Law and You. But when you see the repeat programs, you know that it's because I'm indisposed. Thank the Lord, I'm back. So, do have a pleasant week, brothers and sisters, ladies and gentlemen, boys and girls, and may the good Lord continue to bless us all.
The Law and You, a look at laws in St. Vincent and the Grenadines which affect our daily lives. The Law and You, presented by lawyer panel P.R Campbell QC and brought to you on SVG-TV as a public service.